Welcome back, everybody. Advocates for Justice Paralegal Service. My name is Guy Neighbors. Thank you for watching my video. We tried tonight to go live on YouTube. First time we ever tried to go live on YouTube, we had to have a decoder, then we had to have the YouTube app opened up, and I'm working through the Zoom. Oh my God! So it said my video bit rate was low, so it was making my stream buffer. So that was not going to work. So we're going to try it again tomorrow. I'm going to see if I can do what I need to do to change the bit rate to increase it. According to what I'm showing on my page, I have what I need, but the computer is not agreeing with me. So we're going to see if we can get that figured out tomorrow. So today we're just going to do a regular video. Today we're going to talk about my new lawsuit package, my new credit card lawsuit defense package. And a couple of other things we're going to talk about today. We're going to discuss credit card debt purchasers, what defense you need to use against them, why the defense works, what debt collectors have to prove to prevail. And last, we're going to discuss my new credit card lawsuit defense package and what documents you'll receive when you invest in this package. But before we get to all of that, I want to ask you guys to please subscribe to my YouTube channel, like and share. Even if you're not facing foreclosure, subscribe, like, and share. It helps me provide service for struggling families. And if you're finding your foreclosure pro se and you need a little help, you will find a wealth of information in my videos you will be able to use in your foreclosure defense documents. Pretty much the stuff that I put in my lawsuit packages is what I discuss in the videos. So I'm, discussing that stuff so I can share with you guys information. If you guys are filing your own pro se, filing your own case, and you can take that information and turn it into what you need, got no problem throwing it on the table for you. That's what this is all about. If you don't have the experience to do that, or you're out of time and you need the documents to get this stuff stopped so you don't get kicked out of your house, down below I'll leave a link to my website. You can go to my website and get the documents you need. So if you don't need my documents and you can take the information that I share and put together what you need to make it work for you, that's great. And that's one of the reasons why I do this. Okay, so let's get started. Corporations sell bad debt to purchasers. And now, if the party that's suing you is not the original creditor, you can assert a lack of standing as a defense. When you do this, they will have to prove that they have standing to sue you. An alleged creditor can only sue you if it has a relationship to you to verify standing. And that's something that attorneys don't attack when you're facing this situation. Okay, so to prevail in court, the debt buyer the debt collector will have to prove a few things. Okay, number one, they'll have to prove to the court that it owns the debt. Okay, to do this, the debt collector will have to produce a contract of sale, also known as an assignment, that actually mentions your debt specifically. Okay, if the debt buyer bought your debt from another debt buyer, then it will have to prove a chain of assignment all the way back to the original creditor, alleged creditor. Okay, and I'll tell you why they can't do that at the end when we get done with this. If the debt buyer cannot or will not provide these documents for you, the case must be dismissed. If they can't provide these documents for you and file them in court, the case must be dismissed. Often these debt purchasers will attach a bill of sale or an accounting of the alleged debt, just papers that they copied off the computer, and other documents to the suit to show that it bought the debt from your creditor. But they never attach, they do not They have to prove that they bought your particular account, okay? That's one of the things they have to prove. And that's never put on the table, because most of these people doing, debt collections, attorneys won't help you fight them, because attorneys are not going to help you fight other attorneys. That's generally not the way that goes. If you assert a lack of standing, the debt purchaser must show proof that your account was one of those that it did purchase. Now, this sounds like a lot. This sounds easy, and a lot of debt purchasers can't do it. My opinion is the original contract in dispute was destroyed when the debt was charged off the company's taxes and claimed on the insurance as a loss. I think they destroy it, they shred the document at that point to keep themselves from being, protect themselves and from the evidence showing that they made money. If they made money on the debt after they claimed it on the insurance and after they wrote it off their taxes, it's insurance fraud and income tax evasion. And the reason that is because when they sell these debts at the end of this period of time after they do all these things, they have no place to put this on their books. The money that they got for the debt, they have no place to put it on the books because the books have already been charged off to zero balance. Okay, that's really important. Sometimes the debt's sold more than once. When this happens, the current debt owner they will have trouble getting the documents that is sufficient to meet the proof of requirement to the court. Much of this debt is transferred using computer-generated lists without signatures nor affidavits. Now, the affidavit part is huge, okay? Because just like in foreclosure court, okay, when you go into court, the first thing you should be saying is, hey, there's no witness. Without a witness, the court does not have jurisdiction. And the attorney cannot testify on behalf of the witness because it's considered hearsay third party. The attorney cannot testify, and they can't prove agency. If the attorney can't verify agency, you can't prove the attorney's not working for, the attorney could be working for himself. Oh wait, they are, because the debt's been charged off and they're trying to collect on it. The debt collectors, they don't have any consideration in the deal or whatever. They have no consideration at all. You have no contract signed with them. Their name is not on anything. So that's a problem for them if we learn how to assert this in a proper way. Now, in this case, it will be difficult for creditors to meet the proof of requirements of the court, which generally require that the collectors have a witness that can testify as to the accuracy of the business records at the time they were made from personal knowledge. All of those things are important because these are the things that these attorneys skate around all the time. Okay, they sign the affidavit themselves. Okay, and then they say that they reviewed the record. Well, they didn't review any records because there's no records for them to review. All there is just a billing statement or an account statement saying that this is how much you owed and this is how much that, this is what your last payment was. That's pretty much all they put in it, okay? In our new credit card lawsuit package, it comes with 6 different documents that you need to get control of the situation. You will receive the following lawsuit documents. Number 1, the lawsuit for Fair Debt Collection Act violation in the credit card lawsuit, okay? Because I just told you all the things up here at the top of the list that we talked about, they can't prove, okay? And the Fair Debt Collection Act practice mandates that they can't use deceptive ways of doing things and all that. That's all this is. It's all deceptive because they skate around everything by not following the rules and doing the things they're supposed to be doing. And there's nobody to hold them accountable because the attorney's not trying to get in other attorney's face. But I got no problem helping you guys get up in their face. So that's going to change. You'll also get a new motion to dismiss the credit card lawsuit. And this motion that I put together to dismiss the credit card lawsuit, okay, so this package has been used by a couple of members in my family and a couple of really close friends. and it has 4 wins. Okay, the people never had to go to court. Not only did they not have to go to court, these debt collectors, one of the things that we demand is that they contact the credit reporting agency and they clean up the credit. They remove all of they remove all the false information they told them about you not paying the debt and all that stuff. Okay, and in all 4 cases that took place pretty quickly. And I think part of the reason it took place pretty quickly is because we addressed the fact that if we file a complaint or we file a lawsuit, we're going to include the original alleged creditor because they're violating the laws by selling the debt to these collectors after they've charged it off, after they charged it off of their taxes and claimed it on the insurance. So they were compensated twice. Any money made off of it after that is insurance fraud and income tax evasion. And here's the sweet thing, okay? Anybody that's participating in this scheme down the road, okay, will be charged with the same crimes through the conspiracy statutes. You don't really even have to know, okay, that they violated the law. Of course, these people are attorneys and they know, but you don't really have to know. All you have to do is be involved in it, and through the conspiracy statutes, you get connected with them, and then you could get charged with money laundering, wire fraud, interstate, a whole bunch of things. The same things they try to charge us with. Funny how it goes. Okay, so the second document you're going to get is a motion to dismiss the credit card lawsuit. Okay, that's what you would file instead of an answer. Okay, you always want to file your defenses before you get to any answering anything, because once you file your defenses, okay, especially in this situation, they're pretty much going to be stuck in the water. Okay, the third document is an affidavit. Okay, you want to fill that affidavit out and fill out what's going on. You know, you want to make sure that you use the information in the motion to dismiss to put in the affidavit, so that the affidavit matches with your motion to dismiss and your credit card lawsuit. You know, you want to mention all the things that I mentioned in the beginning of this video in your affidavit. And fourth, okay, I always tell people, if you get in my program, okay, I'm gonna show you how to have fun. Okay, we're gonna have some fun here. Okay, the fourth document you get in this package is a demand to strike the attorney's notice of appearance. That document will be used if the attorney, okay, that's in the law firm or suing you, okay, responds. And the reason I say that is because when you file your lawsuit, you're going to add the attorney and the attorney's law firm as a number 1 and number 2 defendants on your lawsuit. Okay, and then whoever their credit card company, they're saying the credit card company has to be third. And the only reason we stick the credit card company on there is because we need the attorneys to want to protect the credit card company, because this whole thing is a scam. So we go after the attorneys as the number 1 defendant, the law firm as the second defendant, and then the credit card company is third. And the reason we do it in that order is because the credit card company is not the one coming after you. Okay, the people attacking you right now are the attorneys, okay, that buy these debts. They don't have anything to do with the credit card company. So when you file your lawsuit, okay, against them, and somebody from the law firm or one of the attorneys that you have listed in the complaint steps up to the plate and files an answer or whatever, objects to your thing, then you can object and serve the demand to strike the notice of appearance. And when you strike the attorney's notice of appearance, all of the stuff that they file gets stricken from the record too. Okay, that's the way that works. You also have document number 5, a notice of removal and objection to the magistrate judge ruling in your case. So if the magistrate judge rules in your case, the magistrate judge cannot rule in anybody's case without consent from all parties. Okay, so a lot of times what they do is you'll file your lawsuit in federal court or whatever, and then the magistrate judge will look at it and then fill out a report and send it over to the district judge, and the district judge will dismiss your lawsuit, okay, based off the magistrate judge's report, which is total BS. And what they're doing is protecting the district judge from getting sued for violating your rights. But most people don't realize your magistrate judge is a lesser judge. And I don't think, I know I don't want a lesser judge involved in my case, okay? And if you think I'm kidding, Google magistrate judge consent form and then put your state in there. And more than likely, it'll pull up right on their website the consent form that has to be filled out to give the magistrate judge jurisdiction to hear your case, okay? Sometimes they send that out to you, but most people look at it and ignore it, okay? And the way they roll, if you don't object, then you're in agreement. You're agreeing through acquiescence. So if they send that to you, okay, the form giving the magistrate judge consent, I would like fill it out in black marker. I do not consent. Real messy. They hate getting messy stuff that they have to file in their court. I would fill it out. I do not consent and scratch your name on it and take it down there and tell them you want to make sure that this is filed, file stamped in your case, and that the magistrate judge and the district judge both have a copy of it. Okay. That way, if any shenanigans goes down, they both have been put on notice. Okay. Now, the sixth motion is the one that you'll have fun with. Okay. This motion is, well, your lawsuit, you know, $1.5 million. Actually, you can put whatever you want on there. Okay. So your lawsuit that you file for Fair Debt Collection Act practice will be like 1.5 or whatever you want to put on there. The sixth motion is the motion for sanctions. Okay. I have $1.5 million we're asking for sanctions. And here's how this goes. So attorneys are supposed to do a reasonable pre-filing investigation according to Rule 11. And how ironic is this? I actually got this information off the Bar Association website one day when I was researching something and pulled up the bar. I wonder if there's anything on here that can help me. So I went over, yeah, and I found this information. Now, they never give you enough, but they gave me enough to turn on my porch light. And once the porch light comes on, boy, things roll smooth. So this motion for sanction, you would file against the attorneys because they never do any kind of reasonable pre-filing investigation. And your argument here is simple. Had they done a reasonable pre-filing investigation, they would have uncovered all the stuff that we talked about in the beginning of this video, and all the stuff that you mentioned in your documents up here, your motion to dismiss, and your lawsuit for a Fair Debt Collection Act practice. All of those things they would have uncovered had they done a reasonable pre-filing investigation, okay? And usually when, before I started doing the lawsuit packages, this motion for sanctions is what I use to bust them down and force the attorneys to have to hire outside counsel. Yeah, and they're pretty embarrassed about that because, you know, they ain't trying to, their heads are so big, they ain't trying to let outside people know they need them to come in and save them because their butt's backed up against the wall for doing unlawful stuff, okay? This lawsuit package comes with a different kind of support because of the fact that this $850 lawsuit package is on sale for only $200, okay? And I figure it's going to be a lot of people jumping in for this because these credit card lawsuits, okay, start out as a small thing, okay? I mean, it could be, you know, $2,000 or $1,500. You know, it could be much more. I had a lady that had $60,000. One of the ladies that won had a $60,000 bill, okay? And what they do is if you don't show up or don't act or don't defend yourself, they'll get a judgment against you. And once they get that judgment, it could be 6 or 8 months. You know, they'll just turn around and file administrative paperwork and don't even go through the court, okay? They'll file administrative paperwork to start administrative procedure called the wage garnishment. Yeah, some of you know what that is. And boy, that's a pain in the butt to have them taking money out of your check before you even get it, okay? And the sad thing about it is, when they served this wage garnishment paperwork to your employer, okay, it don't have the signature of a judge nowhere on it, okay, but it's written up kind of scary, and people in the office freak out. So they ain't trying to be involved in none of this stuff, have to go to court, they freak out, and they just follow and do whatever it says. It don't matter if it's not signed by a judge, well, to them, well, until you have to threaten to include them in your lawsuit. But anyway, Later on down the road, I have a document for wage garnishment that I'm going to include in this package, but I didn't have it ready yet. And I wanted to go ahead and get this package out because I've got several people that need to use it, but they're not facing a wage garnishment yet. So we will have the 7th document in there to stop the wage garnishment here probably next week when I get around to it. The support for this package will be through emails and through our private Facebook group. It's called Foreclosure Rescue. You guys can find me on Facebook or whatever, and then the group is private because I don't want yahoos in the group stirring up trouble. I'm not interested in a bunch of drama. I need people in the group that's ready to fight, that wants to fight their foreclosure and learn stuff. Okay. And I never let people in the group that are selling other products, because I can control the integrity of the group if I'm the only one in it selling stuff. Okay. And I go through a lot to get the group filled up with people, and I'm not trying to share my leads with someone that I don't trust or even know. The other thing is too, I don't allow realtors in the group. I had a guy one time trying to get in the group, and he had a business the way he boards up houses and stuff, And here's the thing, my group, our private Facebook group is set up to help people stay in their house. Yeah, I'm not going to have anybody in it selling things to help people move out of the house, because that goes against the whole program, what we're trying to do here. Okay. So the support for this package will be through emails and through the Facebook group page. And the reason I do that is because I have a commitment to the people that are invested in my group. And a lot of these guys are getting ready to go to court, and they're calling me with last minute order. The judges respond to things. They're calling me with, asking me questions and stuff. And I need to be able to back them up, like I agreed to do before they purchased their lawsuit package. So, but these other packages that I'm selling them really cheap, because my main goal here is to help people kick attorneys in the face. I'm just going to say it. Okay, that's my main goal. Now, I do like to eat, so I got to make some money here, but we like to teach people how to get attorneys out of their face, because these things attorneys are doing are wrong, and it's unlawful. It's sad. We have been kept in the dark and fed such BS for so long. We believe so many things that are not true, okay, are not true. So we're going to start to change that, okay? Due to a large number of people that will be investing in this package, I want to make sure that people understand that I won't be taking phone calls for this. You leave a question in the Facebook page, more than likely it's somebody in the group that's been through this or had this question answered already for them. If not, then I'll see it and I'll respond to it in the group. It's easier for me to do that than to take a bunch of phone calls, because you have no idea how many phone calls that I have coming in just during the day from people that need help. And then I add that to the people that I've already made a commitment to help, and it gets sometimes overwhelming. So this is going to be the best way for you to get a response and answer. And my email address, you can also email me through winincourts1@gmail.com. I check my email all the time, and I'm pretty much on the computer most of the day. So if you leave a message in the Facebook group, I'll see the little message that somebody left a message in the group, and then I'll go over and see what it is and answer it. So that's the way we're going to handle this. This allows me to sell some packages at a much lower price for people, like credit cards and stuff like that. We're also going to put together a lawsuit for HIPAA violation. That's the next package that I'm going to be working on. People don't realize that your billing information is covered under HIPAA. So when they sell your billing information to a third-party collector, and that third-party collector doesn't have all of the things in place that they need to have to protect your digital information, it's a problem, okay? And yeah, the package for that, my family members have used also, and a couple of friends, and it has, I think it's like 5-0, maybe 6. 5-0, I can remember off the top of my head. And we also have the attorneys contact their credit reporting agency and remove the false information that they reported to them. And this package, the HIPAA package, works really well, because in it we threatened to include the medical facility in our lawsuit that we're going to file if they don't do what they need to do. Okay, and people don't realize that in a HIPAA violation, okay, there's no court hearings, and there's no, if you can prove that you were violated, that your personal and private healthcare information your private healthcare information was actually sold you to a party that was not legal and did not have the legal requirements in place to protect it. Okay, there's no court date. Okay, it goes straight to settlement, and you can look it up and see it goes straight to settlement. So these guys aren't really trying to have to deal with all this, and they sure as hell don't want to have the medical facility that's giving them their bread and butter get jammed up, because if that happens, you know what's going to happen. They're going to get cut loose, and then they'll have to go find some other way to make fraudulent way to make their money. Anyway, so that's what we're working on in the future. This package is on my website now, and I'm going to leave a link to the product page below in case you just want to go straight to the product page and not look at all the other stuff on the website. But I would suggest you check out the website and take a look at all the other things that we're doing. We have some of our videos posted on the website. Also, we have some of our testimonials or Google reviews are posted on the website. We have a question and answer section on the website that people can kind of get a little more information about who we are, what we do. So that's it for today. If you have any questions, you can give me a call, Coach Neighbors, 913-240-0227, or you can go to my website at winincourtnow.com, 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 and check out what we're doing. We're making a big difference, and a lot of people are really happy. And when you go to the Facebook page, you can also talk to some of the other people in the page that are using our documents and strategies and see how things are going for them. We have several people that are still in their house past the eviction time because they used a non-judicial package and they got everything filed the way they were supposed to file it, and they're still in their house. The way that non-judicial package is set up to create a title dispute that you use to block the eviction process. And it's pretty nice. Put a lot of work in putting that package together. Anyway, actually, I have a lot of work on all of the packages that I put together. One other package that I'm going to be highlighting too, probably in a couple of days, as soon as I figure out how to do this live stream on YouTube, is eliminate property tax. And I've been looking at learning how to use my YouTube dashboard, and that package, I have it posted already, but I only have a 2-minute video. Okay, I have a longer video now that explains a lot more about what's going on with all that. But even with the 2-minute video, that package has got the most support and hits on YouTube. So we're going to whip that out, get the longer video done so people can actually understand it better and see if people will be interested in purchasing that package. It's only $850. Most people's tax are 2 or 3 or 4 times that amount. And the thing with the property tax is there's no statute, there's no law that mandates that you have to file your deed in the county recorder's office. Okay. Now, when you started with this property tax thing, okay, the first thing they're going to tell you, oh, well, you have to pay taxes. Well, no, you don't. Okay. And the fact of the matter is, there's no law that mandates that you have to pay taxes, IRS taxes or any taxes. There's no law that says you have to pay taxes. And the way the taxes are supposed to be collected, according to the Constitution, is not the way they're doing it. All that's covered in the document, in the package for eliminating property taxes. But what they try to do when you bring this up, they try to switcheroo the switcheroo. Oh, wait, you have to pay taxes. Well, it's not about paying taxes, okay? What it's about is whether or not there is a law that mandates you have to file your your deed, your property deed in the county recorder's office, okay? Because we ain't even talking about the taxes and none of that. If there's no law that mandates you have to file your deed in the county recorder's office, then you should be able to get your deed back and have them erase any of the evidence that your deed was in the office, because having that deed filed in their office starts your property tax collections. It starts your zoning crap with them telling you when you need them on your yard, and that you can't park on the driveway, and that you can't park on a sidewalk, and yeah, all different kind of stuff. Okay, all started with your deed being in the county recorder's office. And you know, this property tax thing is really interesting. I spent a lot of time looking at this, and the more time, it's kind of like going down the rabbit hole. The more I looked at it, the more I was like, what? And yeah, right. So when it's time to do the property tax thing, okay, you need to remember, okay, it's not about the property tax. What it's about is whether or not there is a law that mandates you have to file your property deed in the county recorder's office. Now, here's the deal. Back in the day, okay, so they're going to tell you, oh yeah, you have to file it in the county recorder's office so nobody can attack your property and do all this stuff, you know, and we believe that stuff for years, okay? But here's the deal, okay? Back in the day, they didn't have all this county recorder's office figuring out ways to steal your money and use your property. People don't realize that the state uses your property deed for collateral for loans from the federal government. So you got like a debt attached to your property you don't even know about. Yeah. So back in the day, okay, you had to take your deed down and you had it notarized and you signed it. You signed it and you had it notarized. Now you went home and you kept it in your Bible, in your family Bible, okay? If someone else wanted to try and attack your property, they'd have to come up with some paperwork that was signed and dated before yours, or it's a done deal, okay? It was simple back then, but now it's real complicated. It's real complicated because they want it that way, okay? Because once your deed's filed in the county recorder's office, they tell you it's protected, but it's not. It's not protected at all. As a matter of fact, this is what you need to think about. I have people in my group, okay, uh, that have paid their property off, okay, and they have the paperwork to show it's paid off. They have the deed, they have all the stuff to show that it's paid off. But wait, somebody filed a fake assignment, a fraudulent assignment against their property and started a foreclosure. So let me think for a second. Where the hell did they get the information from to put in a fake assignment? From the county recorder's office. Yep, they go to the county recorder's office, pull up your stuff, make copies of it, then they go make their own little fake crap, and then file it in court and attack your property. So to me, it looks like the county recorder's office is used for attorneys to be able to, you know, to get in the middle of your business and attack your property. That's what it looks like to me. Now, I'm not an attorney, okay, but I done my homework and I'm not stupid. Okay, so that's the way that goes. So that's going to roll out in a couple of days. I'm going to get that video done, and I'm hoping that people will start using it. Now, one of the things people always ask me when they're talking about the limited property, well, how many have you won? Well, what I do is totally different. Okay, there's no paralegal that's making these documents addressing the issues that need to be in them. Okay, so people can have a chance to make them go sit down and not even want to go to court. And see, that's the difference. Okay, when you address stuff in the conventional way things are done, okay, you're addressing them in the way the attorneys like you to do it. Okay, so they can argue. Okay, and then when the arguing's done, the judge gets to help them. We already know how that works. So my documents are designed so they don't really want to argue so much, because it's going to get things on the record. The judge is going to have to be on the record either objecting to or denying, which could be appealed. And then when it comes out of the appellate court, the judge's name is going to be on this stuff showing what the bank's really doing. Oh, excuse me, what the attorneys are really doing to people. And they ain't trying to have that. So that's one of the advantages that you have to using my strategy and documents. I was talking to a lady yesterday, and she said, well, you know, I really can't trust people. I said, well, I understand. I said, but you got to understand with me, I'm not part of the system, okay? And I'm doing this because of what attorney did to me. Yeah, I lost my property back in 2012, and I didn't learn fast enough. But They treated me like I was stupid, and yeah, it pissed me off. And after I was motivated, and now here I am. I get to use this nice office too. I guess I just know the right people. Anyway, so stay tuned. Please click subscribe, share. My YouTube channel is, we're going to talk, I'm going to give free information out and strategies that you need if you're doing your own documents. So looking at my videos and stuff is priceless, because there's a wealth of information in there that you will be able to use. And like I said, if you don't have time or you don't have the skill to do that, then go over to my website and grab the document and set up a support call. And after you review the document, we'll get on the phone and I'll make sure that you understand the document and strategies, and then you can check with me on the phone. I tell you that what I'm doing is totally different, and I think it's making a difference because it's catching a lot of people's attention. I had a lady call me the other day. It's kind of funny. Usually when people call me, okay, there's some urgency to their voice, and they start right in on talking about what's going on. And, I have to like stop them, ask them what their name is, so I can like address them by their name. And so I had a lady call me the other day, and she started talking to me and asking me these stupid questions. Does the package have to be personalized, and is it already ready to file, and do I file it, and so I knew the lady. I figured she was an attorney. So I just answered her questions, and finally I asked her if she was an attorney. And she said yes, she was an attorney in New Jersey and from another country too. And the funny thing was, when she called me, okay, when I answered the phone, I could hear my video really loud in the background. It was kind of creepy, but yeah. So I know she was watching my video. She got herself all worked up. And so then she asked me if I worked under attorney. And so I told her, no, I don't work under an attorney, but, I hired one a long time ago to help me. And, I got thrown under the bus, so I felt like I was under attorney then. That's what I told her. Yeah. So then she asked me if I had a license to practice law. And so I told her that under Square versus Board of Examiners, the Supreme Court ruled there that no state can license to practice law because it's considered a common right wealth. And then I asked her if she had a license to practice law. She said, well, yes, she does. I said, well, I'm not talking about your bar card. If you've got a license to practice law, I'd sure like to see it. Maybe you can, like, I don't know, text me a picture of it, because I'd sure like to click. Well, okay, first she yelled some things in a language I didn't understand, but then she hung up. So yeah, I think what we're doing is making a difference. And that's not the only attorney that's called me. Last month I had an attorney call me and just started asking me things right out. So I just asked him right out if he could send me a copy of his license to practice law. And if he could do that, then I'd be glad to talk to him about anything he wanted to ask me. Well, he hung up too. No, nobody wants to go there. So anyway, you guys, it's been great talking to you today. I'm hoping to figure this live stream out so I can get on YouTube and rock and roll, but didn't work out tonight. But at least I'm moving forward, and I got everything set up. I just needed to get the bit rate. There was a problem with the bit rates that was making the video really slow. It's going to be buffered, so I would be going, and I didn't want to have that. So. Okay, guys, so I'm going to get out of here. Please remember to subscribe, like, and share. And check down below, because I'm going to leave a couple of links down there to this new package that I rolled out, so that you can see what we're doing. And if you're facing these people are trying to get their hand in your pocket, then this is what you need. Thank you. My name is Coach Neighbors, okay, Advocates for Justice Paralegal Service. We are different, and we prove it.